And do you recall, when was that tax return filed?
That was filed October 17th of 2022.
Okay. Under the terms of your final decree of divorce, who was awarded the marital residence?
Randall Kirby.
And the day after your divorce, did Mr. Kirby receive a purchase offer for the house?
He did.
And did he accept that to the best of your knowledge?
Yes, ma'am.
Okay. I'm going to show you what I've marked, ma'am, as Petitioner's Exhibit 2 and ask you if you can identify that as the settlement statement related to the sale of the marital residence.
Yes, ma'am.
I'll offer P2.
Objection to the relevance.
And just like that, the judge lets the money trail into evidence. This is a huge moment. Why? Because in enforcement hearings, it's not enough to prove someone should pay. You often have to prove they actually could pay. And hearing that Dr. Kirby allegedly received over $650,000 just weeks before the taxes were due. Yeah, that's the kind of timeline that makes a courtroom suddenly get very quiet.
Well, Judge, part of my petition here is that he not only had the obligation to pay, but he had the ability to pay. So certainly the fact that he received $650,000 in September of 2022 is relevant to whether he could have paid the tax debt in October of 2022. And I'm so sorry, Judge, you're on mute.
Sorry about that. Overruled.
Is P2 admitted?
Yes.
Thank
P2 is
you. And so, Dr. Kirby, on P2, what does it reflect? I've highlighted it on line 10. How much of the proceeds from the sale of the marital home went to Dr. Kirby?
$654,248.06.
Okay. And this also reflects that the closing date on the sale of the house was September 30th of 2022.
That is correct. Yes, ma'am.
So about 2 weeks before the taxes were due. Is that right?
That's correct.
To the best of your knowledge, sitting here today, has your ex-husband paid all of the 2021 tax debt that we saw reflected on P4?
He has not.
Did you start receiving notices from the IRS related to that unpaid tax debt?
Yes, ma'am.
And I'm going to show you on my screen what I've pre-marked as Petitioner's Exhibit 3 and ask you if you can identify this as a copy of a notice from the IRS dated November 14th, 2022.
Yes, ma'am.
I'll offer P3.
No objection.
P3 is admitted.
So on P3, Dr. Kirby, does it reflect how much is now due to the IRS on November 30th of 2022?
Yes, ma'am.
And I highlighted that number there, $365,000 and change.
Yes, ma'am.
And if we go to page 2 of Petitioner's Exhibit 3, is there a section that reflects penalties as well as interest?
Yes, ma'am.
And if we look at the line that says total penalties monthly plus daily, does it total $16,179.60?
Yes, ma'am.
And that's a combination of monthly and daily penalties. Is that right?
Yes, ma'am.
Going down below that, the interest section, does it also reflect that interest had been accrued at that point of over $9,700?
This is one of the harsh realities of tax law that shocks a lot of divorced couples. The IRS does not care what your divorce decree says. If both names are tied to the tax return, the government can still come after either person for the full amount. That phrase, jointly and severally liable, may sound boring. Until the IRS starts circling your bank account, suddenly it becomes terrifyingly real.
That's correct.
Now, what is your understanding of whether you are jointly and severally liable on this tax debt, even though your ex-husband had been ordered to pay it?
Objection to her understanding.
Judge, she can testify of her understanding.
The relevance of her understanding.
Okay. Overruled.
Go ahead, Dr. Kirby.
It is my understanding that if Randall Kirby does not or cannot pay those federal income taxes, that the IRS will hold me responsible and can levy my assets and require me to pay it, regardless of the divorce decree, regardless of what the local divorce decree states.
And is your understanding based also, I don't want to get into the details, but is it based also on your hiring and retaining a tax attorney?
Yes, ma'am.
I'm going to show you what I've marked as P5, and can you identify this, excuse me, as a transcript from the IRS dated 2/24 of this year, reflecting how much is still owed on that tax debt as of that date?
Yes, ma'am, that's correct.
I'll offer P5.
Any objection?
Not to P5.
P5 is admitted.
And so we can see here that accrued interest and penalties are continuing to accrue. I've highlighted that line. Do you see that there?
Yes, ma'am.
And that as of, let's see, it looks like as of 3/13, the debt was approximately $175,000. Do you see that?
Yes, ma'am.
After you filed this petition for divorce, or excuse me, petition for enforcement, did Dr. Kirby, the respondent, Dr. Kirby, did he make a payment to the IRS debt?
Yes, ma'am.
And approximately how much was that, and when did he make it?
$200,000 on January 4th.
Okay. Can you tell the court how, let me back up. Has the respondent's failure to pay the 2021 tax debt negatively impacted you and your medical practice?
Yes, ma'am.
Can you tell the court how?
I've had to move offices and have had to pay a finish out fees, building construction fees of $1.1 million to have
Objection to non-responsive is not responsive to how the taxes have anything to do with that.
Judge, she's getting there. I mean, can she be allowed to finish her sentence at least before there's an objection made?
Oh, courtroom tension is rising fast now. Notice what's happening strategically. One side is trying to paint financial devastation, while the other side is aggressively cutting off anything they think could become emotional persuasion instead of hard evidence, and the judge. She's trying to keep this train on the tracks while both attorneys are fighting for control of the narrative.
Yes, Attorney McKnight, allow her to finish the sentence and then you can make your objection at that point.
Go ahead, Dr. Kirby.
In order to come up with the money to pay the finish out, I had to approach a bank to try to get a loan. And I was denied from getting a loan because I have personal
Objection to
income
hearsay?
taxes due of 2021.
Ms. Kirby, when an objection is made, and Mr. Kirby too, if you would just stop what you're saying, allow the attorney to make the objection, I'll rule on the objection, then your attorney will tell you whether or not you can continue with that question, or you'll just stop and they'll ask another question, okay?
Yes, ma'am, I'm sorry.
Okay. Let me scroll back up to the objection. Okay, the objection was to hearsay, is that correct, Attorney McKnight?
Yes, ma'am.
Okay, that's overruled.
So Dr. Kirby, just to summarize, you weren't able to get the loan because you didn't have your taxes paid for 2021.
That's correct.
What are you asking the court to do with regard to your ex-husband's failure to pay off the entire 2021 tax debt?
I am begging the court to have those taxes paid off immediately because I cannot operate my business and maintain payroll for my 20 employees that I pay in order to sustain my practice.
Under the terms of your final decree, who was ordered to be responsible for all debts and liabilities associated with Dr. Randy Kirby's medical practice?
Randall Kirby.
And was he also ordered to indemnify you and hold you and your property harmless from any failure to pay those debts?
Yes, ma'am.
And is one of those debts a business line of credit at PNC Bank that ends in account number 2142?
Yes, ma'am.
And do you have reason to be concerned that your ex-husband has not always been current paying on that business line of credit?
Yes, ma'am.
And so did PNC Bank actually contact you regarding
Objection to
non-payment?
leading and calling for hearsay.
Sustain.
How
That's
did,
as to leading. Sustain is to leading.
thank you. How did you become aware that, or what forms the basis of your belief that Dr. Randall Kirby has not always been current on that business line of credit?
In September or October, I don't remember the exact date, but the bank PNC called me to tell me that
Objection to
Randall,
hearsay.
Sustain. Ms. Kirby, you can't say what someone else told you, okay?
yes, ma'am.
What's the current balance, if you know, on that PNC business line of credit?
I believe it is approximately $180,000.
And are you tied to that line of credit somehow?
Yes, ma'am. I'm a personal guarantor of that line of credit that had been signed and created in approximately 2002 or 2003.
And based on conversations with the bank, don't tell us what they said, but based on conversations with the bank, you have reason to believe he hasn't always been current on that line of credit.
That is correct.
Okay. Why are you asking the court to order your ex-husband to pay off that tax debt so quickly?
Because I cannot access funds to maintain the practice and to grow the practice.
But why can't we just give Dr. Kirby more time, Dr. Randall Kirby, more time to pay off those monies if he needs more time to do it?
Because every day that goes by that he does not pay it is interest and penalties that are accrued to that tax balance. And I am potentially liable for that money if he cannot or will not pay it.
Do you have any concerns about Dr. Randy Kirby's spending habits and overspending habits?
Yes, ma'am.
Can you tell the court what those are?
He currently rents a house that costs over $20,000 per month.
Objection to relevance, objection to hearsay.
What's the relevance, Attorney Rowan?
Sure, Judge. So part of my requested relief and part of what I have to prove to you is that Dr. Randall Kirby has the ability to pay. And in support of why I'm asking that the debt be paid so quickly, it goes to the relevance of that. Because if we are concerned that if he's given a lot of time to pay this thing off, like counsel wants, 90 days or more, that the funds just aren't going to be there and he's not going to be able to do it. So it's absolutely relevant to the date by which I want him to pay.
Objection overruled.
Go ahead, ma'am.
He leases 2 vehicles, each of which are value $180,000 each car. He has approximately $250,000 at least of credit card debt. He's opened an additional line of credit for $250,000.
Objection. May I take the witness on Bodar?
Yes.
Where did you get the information that he's opened an additional line of credit?
I received a bank statement.
Objection to hearsay.
Sustain.
Go ahead, Dr. Kirby. Is there any other reasons why you're concerned about Dr. Randall Kirby's overspending or spending habits?
He also maintains 3 country clubs, all of which cost significant dollars per month. And his income has been decreased in the last 6 months. So in order for him to maintain the expensive house and the 2 vehicles and the 3 country clubs and the multiple credit card debts, he is using the money from the proceeds of the
Objection to
house.
speculation.
Sustain.
So Dr. Kirby, why has your ex-husband's income gone down in the last 6 months, if you know?
He has been in drug and alcohol.
Objection, Judge, I'm going to object. And I'm going to put the witness on notice that he's violating my client's HIPAA rights. And I'm going to object to this line of questioning as it violates my client's right to.
And here we go. The hearing just crossed into dangerous territory. The moment drug, alcohol, or medical treatment enters the conversation, privacy alarms start going off everywhere. The defense immediately pulls the HIPAA card, basically saying, this is private medical information and does not belong on a public live stream. But the other attorney is arguing relevance, saying the issue affects income and income affects whether the debt gets paid. This is where courtroom battles stop being just about facts and become fights over what the jury, or in this case, the judge, is even allowed to hear.
Privacy, his patient-physician privilege. This is a doctor. She should know better. And I'm going to ask the court to instruct her not to bring it up again.
Well, Judge, the biggest exception to HIPAA is by court order. You can order her to answer those questions and she's not violating anyone's HIPAA rights. She testified that she believes his income has gone down in the last 6 months. I asked her, why does she believe that? And she can answer that question. That's not a violation of his HIPAA if you order her to answer that question.
Well, it's going into a medical condition of his that she's aware of, and it's his private matter. This is on YouTube streaming live, and I'm going to object to this line of questioning as it violates his patient privilege rights.
And Judge, if the court is inclined to go into it, I have no problem coming off YouTube. I'm not trying to publicly broadcast it, but I think it's relevant to the inquiry here.
Attorney Rowan, I'm going back and I'm looking at your question. Your question was, so Dr. Kirby, why has your husband's income gone down in the last 6 months, if you know? Ms. Kirby's response was, he has been in drug and alcohol. Then an objection was made. I guess for the court, what's the relevance to his income with the drug and alcohol?
And I'm putting everybody on notice, including counsel, not to violate my client's HIPAA rights. This is protected under the federal law and under the state law. And I'm putting everybody on notice, including Dr. Kirby, that his rights are being violated. I object to this being broadcast. I object to it being on the record, and I object to it being disclosed in open court. And
Judge,
I
may
ask
I
the
answer
counsel move on.
May I
Yeah.
answer your question, Judge?
Yes, but only to the extent that the question was asked, the income relating.
Understood. So we have a problem of income not meeting expenses, and that goes into why we are asking this debt to be paid and to be paid so quickly. So we've testified about all of his expenses and the overspending, but if all you heard is that he makes $3 million a year, then maybe you'd think, well, so be it. He can afford those things. That's his lifestyle. We have testimony and evidence to put forward that his income has gone down and the reasons why it's gone down. I understand the concern about it being broadcast on YouTube. I have no objection to it. Sorry, Ms. Rivera. I have no objection to it coming off of YouTube. I'm not trying to publicly talk about anything on YouTube. However, it goes to that inquiry of the funds are going to be gone if you order this tax debt to be paid after 90 days.
Okay, I believe that.
That's actually a very careful judicial balancing act right there. The judge is essentially saying you can discuss finances, but you're not going to publicly expose deeply private medical details if you can avoid it.
With everything that you presented thus far and probably information known to your client without going into that, the court believes, from what I'm reading, that that inquiry can still be made without going into the anything private dealing with Mr. Kirby.
Okay.
So
Can I try to?
that you ask your next question.
Sure. Dr. Kirby, if you can answer the question without going into private issues regarding your ex-husband's private health information, can you tell the court the basis of your belief that his income has gone down? And if you can't answer it that way, then just indicate that.
Yes, ma'am. He did not work, no work whatsoever from December 2020 through February of 2021. And in addition, did not work with no income generating from November 2021 through April of 2022. And since May of 2022, the income that has been generated is significantly less.
Objection. And at this point, I'd like to take the witness on voir dire.
You may proceed.
Ma'am, do you have personal income, personal knowledge of his income from May of 2022 until the present?
Yes, ma'am.
And how do you know what he's making now?
I am on the banks, the bank statements online.
Are you accessing his account that you're not entitled to have access to?
It is on my login. I can't remove anything.
So your testimony that you're about to give is as a result of you accessing bank accounts that you are not awarded and that are not in your name?
I'm going to object to multifarious.
And I'm going to object as that.
Hold on, one objection at a time. The objection to multifarious is sustained, one question at a time, Attorney McKnight.
And I'm going to object to this witness testifying to any income that she lacks personal knowledge of, and it's particularly about anything that she's illegally accessing without consent. And also it's speculation on her part, what's income and what's not. And I'm going to object on that ground.
May I respond very briefly, Judge?
Very briefly, yes.
The question was about from May 22 forward. These people weren't even divorced until November of 2022. I think she has the right to answer this question if she knows.
Okay. Miss Attorney McKnight, did you want to re-ask Miss Kirby if she knows this information or
Yeah.
not?
So other than accessing his bank account, do you have personal knowledge of what his income is since August of 2022?
You asked me the question since May of 2022. And
So now I'm asking you, since the date of divorce, August of 2022 to the present, do you have personal knowledge of what his income is?
I have knowledge only of what has come into the bank because I am still a signer on that bank account and I'm still a signer on the line of credit. And that is why it is still on my login. That is why I have access to it.
And so you've been accessing his the bank account that's awarded to him?
I have not been removed as a signer on anything.
And aren't you the one that has to execute the documents to remove yourself from that account?
Your Honor, I'm going to object to relevance at this point. I mean, there's.
And I'm going to object to
Hold on,
this.
one second. Hold on, three things. Attorney McKnight, I can hear your client in the background. I know you probably don't want everyone on the Zoom to hear what you all are speaking about. So, maybe just press mute so we wouldn't hear what he says. And Attorney Rowan, Attorney McKnight, we have to have a clean record. My court reporter over here, you guys are tearing her up. She can't write what everyone is saying at one time. So I'm going back on the record. Well, I've been on the record. I'm going back to the line of questioning that we have here. I believe the question was specifically asking about August of 22 until the present time, whether or not Ms. Kirby knew that information. The court is going to go ahead
and boom, sustained. That's the judge drawing a hard evidentiary line. The court is basically saying, if you don't have direct personal knowledge, you can't just speculate about someone's income. This is a classic courtroom problem in divorce enforcement cases. Both parties often know pieces of each other's finances, but proving exact income without documents, records, or admissible testimony gets messy fast. Also, can we talk about how chaotic this Zoom hearing has become? People talking over each other, hot mix, objections flying everywhere, somewhere off screen that court reporter is fighting for survival.
sustain the objection as to speculation.
I'll pass the witness, Your Honor. Well, I'm sorry. Let me back up real quick. Dr. Kirby, was it necessary for you to retain my services to represent you in this case?
Yes, ma'am.
And as part of that representation, did you have to incur attorney's fees for my time preparing for and attending the prior hearings as well as today's hearing?
Yes, ma'am.
Have you had to retain the services of any other attorneys as it relates to this issue of the non-payment of the tax liabilities?
Yes, ma'am. I've retained a tax attorney to defend me against the IRS.
Okay, and what is that gentleman's name?
Joel Crouch, Crouch.
And at this time, do you know approximately how much you've incurred with my firm?
$20,000 to your firm.
And how much to Mr. Crouch?
$13,000 so far.
And are you asking the court to order your ex-husband to pay your attorney's fees as it relates to you having to bring this petition for enforcement?
Yes, ma'am.
I'll pass the witness.
Thank you.
All right, Dr. Kirby, were you present and did you hear your lawyer say that she initially filed for $400,000 and then after she filed, he paid $200,000 to the IRS and therefore she was only seeking $200,000 in the registry of the court? Did you hear her say that?
Yes, ma'am.
And is that what you're saying to the court too?
Yes, ma'am.
All right, I'm going to show you what is your pleading that's filed in this case. Oops. And in your pleading that was filed, you asked for $400,000 to be deposited in the registry of the court, correct?
Yes, ma'am.
And would you agree with me that $400,000 is more than what was owed to the IRS and the line of credit combined?
I'm sorry, can you repeat that?
Would you agree with me that the sum of $400,000 is more than the $175 owed to the IRS and the $180 on the line of credit combined?
Yes, ma'am.
All right. Now, looking up here. All right. And so your lawyer said that she wasn't trying to make the accelerate the note on the line of credit, but looking right here in your pleadings, you acknowledge that he paid $200,000 to the IRS on January 4th of 2023, didn't you?
Yes.
So it's not true to say that that was something paid after you had to file the divorce. The enforcement, that was paid before you filed the enforcement, correct?
I'm not sure I quite understand what you're asking.
Well, if your attorney suggested to the court that it wasn't until after you filed your enforcement that he paid $200,000 to the IRS. Did you hear that?
Yes, but I'm not exactly sure that the timing of when we initially filed for the enforcement relative to the January 4th date.
Well, it says it in your pleading that he paid it, right?
Yes, ma'am, but when I initially,
And in the pleading, the same pleading, it says make him pay $400,000 in the registry of the court, correct?
yes, ma'am.
Now, this is where the case starts feeling less like simple tax enforcement and more like a financial emergency intervention. The request wasn't just pay the taxes, it was essentially freeze the spending before the money disappears. That's a bold ask, and it tells you how worried one side is about cash burn, luxury spending, and whether enough money will still exist when the court finally rules.
And in your pleading, you wanted him not to be able to spend any money whatsoever from any source until he paid the line of credit in full and until he paid the IRS in full. Is that correct?
Yes.
Okay. Now, I want to look, is it true that since the date of divorce, Mr. Kirby, so we've established that since the date of the divorce, he paid $200,000 to the IRS, correct?
Yes.
All right. Now, looking at your exhibit number 4, the tax return, I'm going to show you what's been already offered into evidence. This is a letter dated. When is this letter from your accountant firm dated?
January 19th, 2020.
Okay. That's this year, right?
Yes, ma'am.
Okay. And so you and he got these tax returns in January of this year, correct?
That is not correct.
Okay. Well, and this is when we found out how much was owed. Isn't this when we actually found out how much was owed to the IRS?
No, ma'am, that is not correct.
Okay. Well, this is what the date of the letter is from your accountant enclosing the tax returns, correct?
That is the date of when they sent the copies of the paper copies, but that is not the date on which we knew how much taxes were owed.
All right. And in your pleadings, you say the taxes were due on April the 15th, correct?
April the 15th of 2022.
All right. And is it true that you filed an extension at that time?
Yes, ma'am.
And the taxes weren't filed until late, correct? Or they were filed in October of 2022?
The filing was done in October of 2022, not that
Okay.
when the taxes are due.
Okay. So so in August, when we proved up the case, the tax return had not even been filed yet. Is that correct?
That is correct.
And do you remember coming to court in August, and I was there, and your attorney was there, your other attorney was there, and Dr. Kirby was there?
Yes, ma'am.
And do you remember that you were asking for the specific release that the proceeds from the sale of the house must go to pay the taxes at that time?
Judge, I'm going to object as to relevance. I don't know why we're talking about things that go behind the order, that go behind the divorce decree.
Sustain.
All right. Now, the issue about whether or not, so the proceeds of the house, those are not secured. Nothing is secured by those proceeds, is it? In the divorce decree?
No, other than the house mortgage.
All right. So I'm going to show you what's already in evidence in your exhibit of your P number 2, the proceeds from the sale of the house. I'm going to ask you to look here at line 11.
Yes, ma'am.
Do you see that?
Yes, ma'am.
All right. And do you remember at the time of the house sale that there was an unsecured note with PNC for $725,000? Do you remember that?
Yes, ma'am.
And do you remember that you would not cooperate with the sale of the house until unless that note was paid in full?
I'm going to object to going behind the prior order, going behind the final decree. There's absolutely no reason for it, Judge, and it's inappropriate. It's getting into parole evidence. The document speaks for itself. The decree says what it says.
This is after the decree. This is after the divorce was rendered.
You're asking about things she agreed or didn't agree to in negotiation of the divorce decree.
No, I'm telling her, I'm asking her. That's not what I'm asking.
One moment. Do not address each other. Do not address each other. Anything going behind the order is not going to be considered and is not proper before the court. So anything behind the order that is being asked is sustained.
This is a subtle but important legal moment. The judge keeps shutting down attempts to revisit negotiations or arguments from before the divorce decree. Why? Because once an order is signed, the court usually treats it as final. In other words, this hearing is not about relitigating the divorce. It's about enforcement. Huge difference. One side wants to reopen old fights. The judge wants to stay laser focused on what happened after the order was entered.
Anything that is after the order, Attorney McKnight, you are free to ask those questions.
Now, after the divorce was rendered and granted, the house sold. Do you remember that?
Yes, ma'am.
Okay. And do you remember that at the time the house sold, after the divorce was rendered, there was a $725,000 unsecured note to PNC?